By the way, so if you take a look at a lawyer, an accountant, these are the two musts that you have to have in your business. It's not something that you just, oh, I'm just going to go and, at least for me, it's not something I'm just going to go on the cheap. And
lunch with Norm, lunch with Norm, lunch with Norm, lunch with Norm.
Hey everyone, it's Norm Farrar, aka the Beard Guy here, and welcome to another Lunch with Norm, the e-commerce and Amazon FBA podcast. Today, we're talking, and we're not going to make this boring, we're talking about legal trends and issues with Amazon in 2023. We're going to be talking about trademarks. We're going to be talking about how sellers can be more proactive about protecting their Amazon business. What's the status of your e-com exit? What is that market looking like? Has it dried up or is it still lucrative? And what challenges do Amazon sellers face when they're selling their business? All right, sit back and relax and welcome to another Lunch with Norm, the e-commerce and Amazon FBA podcast. Okay, today, legal trends and issues with Amazon 2023. Our guest, I've tried to get him on here for some time now. So this is a surprise that this is going to be his first time on, but our guest is the attorney. He is an attorney in private practice focused in the field of e-commerce law and the founder of sellerbasics.com. He understands the issues of that e-com business owners face day to day and focuses on being ahead of the issues that have the potential of changing e-commerce. In 2021, he and his partner helped Amazon sellers realize over $250 million in exit proceeds. First-time guest and a buddy of mine from, she's all over, but Puerto Rico was the last time we sat down, had a cigar together, and this is Paul Rafelson. So we'll get to Paul in just a second, but first a word from our sponsor. This episode of Lunch with Norm is sponsored by VAA Philippines. Looking for a high-quality virtual assistant for your business? With the rigorous screening, intensive Amazon and Walmart training, and ongoing professional development, get the peace of mind with skill and motivated virtual assistants for a long-term working relationship. Hire through VAA today, and now let's get back to the show. Now sit back, relax, enjoy the episode, and welcome Paul.
All right. How's it going?
I'm doing okay. The last time I saw you, it was 4 a.m. or you left at about 2:30. Kevin and I were in the cigar lounge till about 4:30. I'm surprised they never kicked us out, but that was in Puerto Rico.
Yeah, they so I think my flight was supposed to be at like 1, and then it was delayed and delayed and delayed. And so yeah, I had to be at the airport. So like I ended up not going to the airport till about 4 a.m. I don't, all I know is I got back to New York. It was like almost 9 in the morning when I think I was originally supposed to be back by like 3 or 4. It was crazy. It was or 5 or 6 or something, but it was like a really long and tiring delay. But I had a lot of fun with you guys sitting in the lounge. It was really interesting to hear a lot about you guys and your, the stories and backstories. It was really a lot of fun. I definitely was the best delay I've ever had. So.
And right back at you, because again, this is going to just lead into going to these events. So I think the World E-commerce Forum, we actually have a link for free tickets. So no charge whatsoever. So if you're in that area, you can use it. There's no affiliate fee. I am speaking, but it's the events where things happen. And at Kevin's event, it's great, high level networking, but we've never had a chance to really sit down and talk.
No.
And during the event, we went out and we had barbecue together. And that's when we started talking. And then, the next day or a couple of days after, we actually had a really great conversation. And this is where breaking bread with people, being able to sit down, some of them, it had nothing to do with Amazon. It was just hilarious or funny stories or just interesting stories that happened in the past. And a lot of them were you, by the way. And actually I remember Kevin and I were walking back just back to the lobby, and it was like, wow, I never knew that about Paul. That was really interesting. So get out there, guys. Get to these sessions and get to meet people. I say that all the time. But now let's get into this. Let's talk a little bit about where should we even start? Why don't we start with trademarks? We started talking about that at the very beginning. Why don't we talk about that? What's the right and the wrong way to do a trademark? And by the way, guys, we have a really, really good giveaway today on the Wheel of Kelsey.
Yes, it's a very inspired giveaway, which we'll talk about when the time comes, but it's a good segue to getting there eventually. But yeah, I think, the mistakes people make with trademarks is just not doing the research. So, we can file your trademark for you, just like any other service can, whether it's a law firm or if you use, Trademark, one of those types of services. But the analysis we put in, people don't realize, like, you're about to invest. And I think this is in part Amazon's fault with the way they run the brand registry. They give people the impression that all you need is a trademark application and you're good to go with brand registry. But what they don't realize is, like, if that trademark fails, right, you've just wasted a ton of money and a ton of time building out a brand that you can't use, right? And Amazon will eventually close down your brand registry and shut it down if your trademark doesn't go. So, putting in the work beforehand to kind of make sure you have a good trademark, I think is really important. That's the first mistake I think people make. And we've seen that a lot, especially people coming out of different courses and thinking, okay, they're not really getting the training they need or the understanding they need that, this is the most important asset to your business. When you sell your business, your trademark really, really encapsulates the majority of the value, what you're getting paid millions of dollars for. It's your trademark, which encapsulates the goodwill that's related to your business. And so that's really important. So that's one mistake people make. The other mistake, which is becoming my pet peeve in the world, and it's sort of something that I'm like on a mission to sort of address, is private label sellers. So we do a lot of M&A. We help our clients sell their businesses, right? So when you sell your business, you have to make certain promises about your business, about like that you have title to all of these assets, right? If I had a company that was called, Apple cell phone accessories, right, and I've managed to fly under the radar, but now it's time to sell it, I might have a problem promising to the buyer that I have the right to use Apple cell phone accessories as a trademark, right? So it's a really silly example, but I just want to make the point that you have to own the IP. The problem, what I see a lot of Amazon sellers do is they register that one trademark because maybe that's what their course person taught them to do, and that's it. And then they come up with like 7 different variations, different logos, different slogans, and none of that's registered. And now they're going to sell a business. It's like, wow, your hero variation, right? And what do I mean by variations? Think Kellogg's cereal. Like the easiest way to think about it is go to the cereal aisle. Imagine yourself in the cereal aisle of your grocery store, right? And there's Kellogg's cereal. Well, we all know the brand Kellogg's, right? But there's not just Kellogg's, right? There's Fruit Loops, there's Rice Krispies, there's Raisin Bran, there's all these other sort of sub brands. And that's what people are really ignoring when they come up with variation products, is they're not, they're giving it cutesy names, right? Like, Radical Raspberry or something like that. Let's say that's a flavor or scent or something, but they don't actually go as far as to register that with the trademark office. And then when it comes time to sell, that could be a real problem, because if that's a very valuable SKU and you can't prove that you own it, right, and nobody else has a claim to it, this makes a very uncomfortable exit. I'll just leave it that way. And sometimes can be a deal killer.
Right. I'm wondering about, so a lot of people try to do this themselves. And I say this on some episodes, there's a right place and a wrong place to spend money. And IP is definitely a right place to spend money. But when I say spend money, I don't mean be cheap. It'll come back and bite you. So I don't know about you, Paul, but there's a lot of places out there, and there's a lot of people that have masterminds that say, oh, you don't need a lawyer.
Yeah, I mean, we deal with that a lot. Like I always sort of joke and say, as a lawyer in the space, like my biggest competitor is like LegalZoom, right?
Mhm.
It's this idea of DIY. And I think that's a mistake. I mean, for one, again, with trademark, I mean, people have no clue. They just look at the, this is what a classic DIY trademarker does. They go on the US trademark office, they punch in the name, like as if it's a domain, right?
Right.
Like as if they're doing a domain search, like, oh, name doesn't show up, and there's nothing really that close, so I should be good to go. But that's not how trademark works in our country. In America, the United States, trademark is about first to use, not first to file. So you can have trademarks being used in other contexts, and that company using the trademark could have a prior claim to you. Even if you were first to file, they can claim, hey, we were using this first, and we can prove it, right? Then there's the issue of, well, what if your trademark just isn't appropriate? Like, let's say it's descriptive, or let's say it's, you used a point of origin, like, Boston baked beans or something like that, right? That can be an issue too, depending if you're from Boston, if it's directly correlated to where the product is from. But there's all these other issues. And so, yeah, working with a lawyer, I mean, to me, if you're serious about building your business, and this obviously sounds self-serving, but it's really not, because it's just common sense. Like, business is complicated, right? Amazon is complicated. It's much more complicated today, especially than it was, 10 years ago, right? Amazon takes everything seriously. They want compliance. I've had clients who come to me and saying that they're having FDA, Food and Drug Administration issues, registration issues, because their product was never properly registered, because for the last 10 years, Amazon didn't care. Suddenly Amazon cares. And they're like, oh, shoot, I should have registered this product. I'm like, yeah, you should have. And it may take a long time now before you can get there. So we see a lot of this, like people just kind of ignoring legal. And then maybe in part that's because it's expensive. So we've created programs to make it a little cheaper, like Seller Basics. We've kind of created this cool program where you can at least talk to a lawyer for $100 a month and not feel like you're going to get this crazy bill. We try to do flat rates through the law firm as much as we can, depending on the nature of the product. But I mean, I think people miss this opportunity to build a relationship with a lawyer who's knowledgeable. I think an LLC is a perfect example. You go out, you form your company, but you can do it yourself, and you can hire one of those entity mill programs to do it. But you just miss that opportunity to build a relationship with a lawyer who can help you through that sort of launch, grow, and exit of your business. And that's what we focus on, right? We're focusing on building that relationship. And we understand startups are not flush with cash. So we've also built our business to be easier on the front end, and to grow with, right? So I actually think we invest in our clients, to be honest with you. Like, that's how I view it. Like, we invest in our clients. Like, we're not out there trying to pinch for every dime on the front end. We understand you're starting up. There's a lot of expenses. You're trying to cover a lot of things. So we kind of like to go easy on the front end. And then as you grow, then we can start, charging sort of our regular rates as we should as a lawyer, right? The investment starts to turn. Not everyone, a lot of our clients don't go anywhere, and I think it's a great model, because I think during the big exit bubble of 2021, especially when the aggregators were in full force, I mean, I had clients who I knew from like 2017 who were barely doing a couple $100,000 who were selling businesses now for 10 million. So it was very bittersweet to see that investment that we make in our clients pay off, everyone's happy, right? So that's kind of our philosophy and how we approach it. But I agree with you. I think people should build a relationship with their lawyer. I think it's something that is odd to me. People are so eager to get an accountant. It's like the accountant, not even an accountant, like the bookkeeper. It's just like taking your data using A2X software and presenting it to you in a, and they're not even qualified. They don't even have to be a CPA. It's like, I've heard people spending thousands and thousands of dollars a month on bookkeeping. And I'm like, what do you think? What do you think they're doing for you? Like, they're literally just taking your data, running it through, presenting it to you. I mean, you should be able to do that much cheaper. But it's funny, we're just a lot of people have made the point of saying, like, they don't need the lawyers, and maybe we're the first to go in the generation. Who knows?
It doesn't make sense, when you hear something like that. If you truly are or want to be a brand, and you're not just testing the waters, the best way to protect yourself, but also it's an asset. Like, when you start looking at these trademarks, like, what is it worth for you to trademark? And by the way, so if you take a look at a lawyer, an accountant, these are the two musts that you have to have in your business. It's not something that you just, I'm just going to go and, at least for me, it's not something I'm just going to go on the cheap. And if I'm building a business, I need an accountant and I need a lawyer. An accountant is not a bookkeeper, and the bookkeeper has got to know e-commerce.
Yeah.
These are the things that you need to run a business. And if you're worried about a couple of $100 there, if you're like, and I'm talking about people that are now up, they're selling, they've got the 6 months to a year behind them, and they know that this is where they want to go. It's something that you got to look at. One of the other things I want to talk about, Paul, is in a trademark, if we can get a little bit deeper into it,
Sure.
You don't go to Tess and just check it out. It says, oh, no words have came back or no phrases come back. I would go to a lawyer that's an IP lawyer that could go and check this out for you. You go and you create a name search and you do the research. That's part of the cost involved. But also there's classes. And a lot of people don't realize about if you're doing certain things, you might have to, buy different classes. For example, like if you're doing print on demand, you might have something that's for apparel. You might have another class that's for, who knows, coffee mugs. But can you get into that? Because I don't think anybody talks about the different classes that you might need when you're selling products with that trademark.
Yeah, I mean, I think we see mistakes made all the time. People choose the wrong class. It's people choosing one class. Like again, this goes back to my point about sort of why we're like encouraging people to go through these trademark audits, right? That my trademark attorney Bethany is sort of spearheading this project of like sort of getting people to go back and look at their IP, because it's like, okay, when I started selling golf tees. Okay, I've got branded golf tees. And then I expanded into golf club covers, and I expanded into like socks, and I expanded into, and it's like nobody ever goes back and adds the classes to the trademarks that they need, right, when they do those things. And that's really common because, again, there's this sort of like disconnect with Amazon. Like once you have brand registry, you're done with trademark, which is the biggest mistake we see. So we see it all the time, or people file and they want to change your class midway through. You can't, right? You got to start a new application, right? You can't amend to change the class like midway through the application. Like if the trademark office says that you're in the wrong class, like you can't go back and refix it. Like you got to start over. And it's such a slow process now to get a trademark. It's taken over a year, right? From the time you file to the time they actually approve it, right? And you actually have a registered mark. It's taking well over a year, right? Like since COVID, it's gotten worse. Used to be like 8 or 9 months. Now it's like a year. I don't know if it's gotten better. Maybe it has, but that's where
I think it's probably still around that. I think it's still,
yeah. So I mean, you don't want to mess this stuff up because you don't want to, and again, like you said, like you're going to sell your business, right, one day, and it's like you don't want to find out in the middle of the sale, like, hey, your buyer's uncomfortable because you can't prove you own the trademark for the class of product you sell, or you don't own the trademark for the variation, the name of the product that you're using, right? Those are the points that we're trying to make and saying, like, people should really take a deep dive trademark audit, right? Now that you're on your feet, right? It's one, I get it. If you're just starting out and you're like, cash is tight. But if you're cash flowing and doing business, you really need to go back and start auditing those trademarks. If you have any, especially if you have an intention of exiting one day, but even if you don't exit, it's still important because if you don't have the right trademark or the right class, right, for the products you're selling, somebody can stop you from selling them, right? Somebody else can come in and say, hey, I had that before you. Because one of the things we do when we run a trademark search is we're not just looking at tests, we're looking at the entire internet, right? Like we use third-party service providers that go and scour the internet for that word, right? And they look for examples. And sometimes, I found, oh, the trademark looks good, but apparently this is a product made by L'Oreal with that name. Do you want to go up and battle L'Oreal for that trademark?
Yeah, like, really.
That's a risk you have to know, right? And some people might say, hey, I'll give it a shot. If they stop me. I'll take the risk, but a lot of people, it's, you need to know those things. So those searches are really important. Knowing your classes, having a sense of vision where you're going to go from here. So not just sticking to the class that you're in, but other classes, like you said, thinking more holistically about where you're going to go from here. What's a natural point of expansion? Should you start buying those classes now? Even if you don't want to pay for those classes now, at least seeing if they're available, because if right now, oh shoot, like in the mug, in the mug category, I can't get this trademark and you're trying to do print on demand, like that could be a problem for your business, like you said. So you want to know sooner than later. That's our point of view.
Yeah, one of the other things too, when somebody comes down on you or starts to file a complaint, so in Amazon, your listing comes down. We've had this with a brand that we work with, and they were surprised. All of a sudden, boom, all their effort they put into YouTube gone, like immediately. Not, I mean, immediately. And all of a sudden, bang, 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 they were just shut down, shut down, shut down. And the other thing that can happen here is if, and again, with a trademark, it's about causing confusion in the marketplace, right?
Right,
So
exactly.
it doesn't have to be the exact word. It could be cause confusion. And I'm thinking of, Kelsey knows what we're talking about right now. There's a client we're working with that spent a lot of money on trademarks, and a company that I wouldn't even think was similar, but it is similar a little bit. And they've come back and they've caused this company hell. And also, the other thing that can happen, tell me if I'm wrong, if you have a website that's let's say it's Amazon, or if it's e-commerce, like a Shopify store, they can come after you for loss of profits, can't they?
Absolutely, especially if they're registered. If they're registered, they can. So if they're not registered, right? I think they're capped at lost profits, but if they are registered, you can start bringing statutory damages as well. So you can really
And
amp it up.
that's not like, to get a trademark is not that bad. When you start with lawsuits and having to deal with that, don't wish that on
Yeah, I mean,
anybody.
it's easy to get shut down when you don't have it, right? I mean,
Right.
we charge. I mean, we charge. I think like if you're a member of our seller, if you're a member of the Seller Basics program, which is separate from our law practice, but we
Yeah.
offer discounts, right? We have a network of lawyers, including our own, who offer discounts to the members of Seller Basics. I think it's like $7.99, including the government fees, which are like $2.50. So we're paying like $500. Like I've got to pay my paralegal, right? But we're not making bank. Like we're not. We're similar to trade marketing. Like we'd have to be doing massive volume of trademarks for it to make any money. Same with
Yeah.
LLCs, but we do it because we have to. It's like it's our, again, it's in my opinion, like the quote of the day from Simon was my statement of build a relationship with a lawyer. That's how we view it. Trademark filings, LLC filings, that's build a relationship with a lawyer.
Right.
101. Like this is how we get to know you. It's how we start, but it's not a moneymaker for us. And our law firm is not, built to do 1,000 quadrillion trademarks like some of the other software, bigger services are, but that's not the point. So it very much is a loss leader for us to,
Right.
to do LLCs and trademarks, but we want to get people in the door and get to meet people that way. So.
And on that note, it's the bottom of the hour. And if you're watching, we've got quite a few people watching right now live. If this is the first time that you're watching, we have something called the Wheel of Kelsey at the top of the hour, and that's a giveaway. Usually, our guests are providing something, a service, consult, and we have a great giveaway today. And to enter, it's hashtag Wheel of Kelsey, tag 2 people, you get a second entry. Paul, what are we doing today?
So in the spirit, again, because today trademark is my campaign, right? This is something that I think is important that I think sellers have ignored. So I know that a lot of people watching the show probably aren't people who are selling for the first time. So you're probably wondering, why would I give out a free trademark filing? But that's what we're giving out today, because that's what we're talking about here. Everybody needs to go and look at their trademarks and see what needs to be filed. Everyone needs to do this sort of audit of their IP and say, okay, here's where I can get new trademarks. So today's giveaway is a free trademark filing with our firm. And so whoever wins, we look forward to meeting you and hopefully getting something on file for you, whether it's for your
That's
new brand
fantastic.
or for your existing brand. We're looking forward to it.
Perfect. All right. So, Kels, let's go to a word from our sponsor, and then we'll come right back. This episode of Lunch with Norm is sponsored by SureGo Marketing. Ready to take your brand to the next level on TikTok and Instagram? SureGo Marketing specializes in helping entrepreneurs and coaches build profitable brands on TikTok and Instagram, and in less than 90 days. With SureGo Marketing, you could build your brand, create incredible video content, and increase leads without spending a single dime on ad spend. Visit SureGoMarketing.com today and elevate your brand. Now, let's get back to the show. Okay. Any other types of IP that sellers are making mistakes with?
I mean, there's always mistakes with, copyright. It's also they're making mistakes with how they're using brand registry. I mean, copyright is an easy low-hanging fruit. It's pretty easy to file those. I mean, you could probably do them yourself. Um, with respect to exits and IP, I'm a big believer in cataloging what you have. So, because this comes up all the time, buyers get really annoyed when you don't know where your IP is from. What do I mean by that? Like you use somebody on Fiverr. Who did you use? I don't remember. Where did the person on Fiverr get the images that they're blending into your, like if they're using stock photography? Where did they get that from? What
Yep.
what agreement did they use? Um, I mean, I've seen situations where people have used stock photography on their packaging, and the licenses have limitations, right? Like you're not supposed to use it on packaging, or if you do use it on packaging, you have to buy the license again every 1,000 units or something like that, right? And nobody's policing that. So tracking your IP is super important. Your copyrights, patent. I'm a big believer in, if you think you have something worth patenting, it's worth exploring. The problem with patent is it's very expensive to obtain. It's also very expensive to enforce, right? So, and depending on the type of patent, there can be workarounds, but in certain cases, patents can be very valuable for your business. But again, you got to do that right away. I mean, you have, basically a year from when you first publicly show the product for sale, right, in commerce. You pretty much have a year. It's called the grace period, right, to get that on file. But I think just generally speaking, people just need to sort of catalog their IP, whether it's photos, whether it's listing content, whether it's what we call common law trademarks that need to be registered. People need to start taking ownership of that stuff right now.
When I was much younger, beardless and hair, I had hair and hair. I used to do the cheap man's registry, and what I would, and I don't think I know it's first to publish, but I just took a printout of my logo or website, and I just mailed it, registered mail. I've got stacks from back in the 90s of all these logos and websites in the 2000s that I owned. And anyways, I just sent them to me registered mail so I could prove that I had published it without a trademark. But now I try to trademark anything that I do. And for copyright, let's be clear about this. I've heard people say that as long as you can prove, like you can use a Wayback Machine, for example, but as long as you can prove that your copy, either on your website, or let's say your website or your blog has been published on a certain date, that's fine. You don't have to register. Is that different?
It's the same thing. Again, two things occur when you register. One, it secures your place, right? Removes certain doubt, and two, it accelerates your damages, right? So again, you're limiting to lost profits if you're not registered. Whereas then, if you actually have a registered copyright, you have the ability to achieve statutory damages. You also need a copyright to be registered if you want to take somebody to court on a copyright issue. So if you have a serious copyright, and I encourage people to, I love to tell my supplement clients, I always tell my supplement clients tend to fall into the trap of using really generic looking labels that can be easily ripped off without like not a copyright violation, right? Like if your label is just like a two-tone color thing, right? Like the copyright office isn't going to give you a copyright on that. It's probably not going to qualify for trademark or trade dress. So you're probably, what tends to happen, I see this in supplements a lot. You might see it in other products where, okay, this, I have a vitamin D supplement with this sort of generic looking label and it says Paul Labs, right? The next guy comes up and he's got, Bob Labs, and he just literally looks just like my product, but it's $10 cheaper. And the user on Amazon, it's a very visual medium, right? They're scrolling through. They may not even notice the difference in the text because it's so subtle, but they see the color scheme. And, oh, that's my usual for vitamin C or whatever, and so they buy it. And I always encourage supplement sellers, like, use copyright, make some cool drawings, get some cool drawings, commission them, put them on your bottles so it's harder to rip off, right? Use IP to your advantage, right, to distinguish yourself so that you don't have to worry about rip off people trying to visually sort of hijack your results in the listing page, on the results page. So that's one thing. I really encourage people to use copyright. Registering a copyright is really cheap. I mean, it's a few $100, and you can do quite a lot at once. So especially with photos. But like I said, if you want to sue somebody for copyright infringement, so you've been infringed, you have to first register that copyright. So you need it to be registered really to take any legal action in court. And so worth having because it's very cheap to obtain, and I think people should go and file for copyrights. Again, I don't think we charge very much at all for helping people, but we also encourage people to do it on their own because it's just that basic. It's pretty easy.
Right.
We don't, we're not trying to make it more complicated than it seems. It's an easy one. So I think that's important. I think the other thing on IP to talk about is just how people are misusing brand registry. I think it's worth talking about that, like it's not, especially trademark, like when somebody sells your product, I just want to be clear about this. When somebody sells your product on your listing, right? So you're selling, you're selling these coasters, okay?
Yep.
You're selling these coasters. If somebody comes up and they have, 2 cases of your coasters somehow, but they're authentic, right? Not stolen. Like maybe they bought them at Walmart, maybe they bought them somewhere else, but they somehow got two pallets of your coasters and now they're selling on your listing. That's not a hijacking. I just want to be clear because Amazon does not view that as a hijacking.
Right.
Amazon views that as a valid third-party reseller, right? And if you don't like that person on your listing, there might be ways you can go about scaring them off the listing, right? There are law firms that specialize in that.
Mm-hmm.
But what you don't do in that situation is you file a brand registry takedown. Because if Amazon finds out that you did that, and they find out that the person's products were authentic, like let's say they have receipts from Walmart or some credible source, right? Let's say they're very credible invoices, or they bought it directly from your website, right? So they can show they bought it directly from you. If Amazon finds out that that's true and you filed a counterfeit takedown or trademark takedown, Amazon doesn't see it that way. They don't believe that somebody selling on your listing, as long as the goods are authentic, is a hijacker or is violating any trademark law. And it says they actually put it in their business solutions agreement that they support what's called the first sale doctrine. And what we're seeing is, and this started with some of the work we were doing with our resellers, right? Because we help a lot of resellers too. Like half of our business, especially in the Seller Basics side, half that business is helping resellers, retail arbitrage, wholesale. And what Amazon started doing is they started punishing people who use brand registry to take down resellers of valid, authentic products. So what I'm here to tell you is that's not the move. Don't go filing IP takedowns against sellers just because they're selling your product. You really need to do the investigation. Obviously, if it really is counterfeit, that's a different story. If you want to scare them off your listing, there may be another way to do it outside of the Amazon ecosystem, but don't use the brand registry takedown unless, something is truly counterfeit, like you didn't make it. That's one way. Or it can be trademark infringement. Most likely trademark infringement won't occur on your listing. It'll be some other listing, right? So they're using your trademark on another listing, right? That's where you would use a trademark takedown typically.
One of the things that I try to do, first of all, exactly what you said. Just because you have somebody reselling doesn't mean that they're a counterfeiter or a hijacker. If I see this, what I tell any of the brands that are working with us, buy it. Just buy it and see if it's counterfeit or not. And if it is counterfeit, I take a picture of it. I'll take a picture. I'll just grab some craft paper, throw it back to Amazon and put on the outside, do not restock. This is a counterfeit, and send it back to them and then make the claim. But another thing that I see is misused is Project Zero, where people think that they can just knock, just kick off people who are counterfeiters on the site. And that could come back and bite you, like you were saying. If this is a legit brand or this is a legit reseller, you just did a you could end up with a lawsuit on your hand because they were legit. Is that correct?
Yeah, no, absolutely. If you file, it's funny, we had a case, this was a patent abuse case. So we had a client, 2 clients actually, who were selling a kitchen product with a bamboo lid. And this like patent troll in Florida, I don't know, these young kids decided that, they claimed that they had a design patent on this thing. And so they took our clients down. Well, our clients came back, we did some research, and we found a couple things. One, we found one of the things about patents that people have to understand, and this is what we always tell people to do whenever they get involved in a patent dispute, is to first figure out, when was the patent actually originally filed? Like, go back to the original first. If there's a provisional, go back to the provisional date. If that date is 2020, okay, let's say it's January 1st, 2020, probably, right? Now let's go to January 1st, 2019, 1 year before. That's our grace period. Now what I want you to do is I want you to search on the internet, YouTube, eBay, wherever you can, Wayback Machine. Find me something that looks identical to that product from prior to January 1st, 2019. Even if it's not yours, did it exist? Because the theory with the underlying point of patent is you can't patent what's already invented, right? I can't patent this coaster. It's already there. It's already made, right? I can't go and file a patent. It's disingenuous. It's prior art. So what happened here was we actually found an IKEA catalog from 2016 in Sweden. So years and years before this patent was ever filed. And we bought it. It was like $5. And we used that catalog to show to the court that our client wasn't infringing on any patent, that this was a bogus infringement. And what was really interesting about the case was one of the first times we ever got the court to do this, the court actually said, because we had told them about the IKEA catalog and they refused to retract their claim against my clients, right? That they basically maintained their position, right? That they stood by their claim. They were now subject to deceptive practices damages under the state Deceptive Practices Act, which really opened them up to liability, which was the first time, so it was a really cool ruling, because it was like, yeah, you can get in trouble if you start willy-nilly dishing out those IP infringements. I mean, you do have some latitude to assert, right, patent infringement. You have some latitude to insert trademark infringement, but if you're doing it maliciously, absolutely, it can come back to bite you in a big, big way. And as Chuck is saying in the chat, like people have lost their brand registry rights, 100%. We are aware of that. We're trying to, and we help people try to get it back, because sometimes even when they're right, they're just doing it wrong, right? And it looks abusive, and we have to show, well, no, here's what happened. But you really got to stop using brand registry in this way. It's just not what Amazon's intent is for it. And the other one that people abuse is not Project Zero, the stickers. What I would say, the authenticity.
Oh, transparency.
Transparency. Thank you. Sorry, I had a brain fart. Sorry. So the idea behind that program. So transparency, for those of you who don't know, is this idea is that you're supposed to put a sticker, right? You got to pay like what, a penny or two for each sticker, but you're supposed to, you put a sticker on every one of your inventory units. That way, only units with that sticker can be admitted into Amazon FBA or can be merchant fulfilled. Like if you don't have that sticker, you can't list, right? If your product doesn't have a sticker. So by entering the program, people think, great, I'm going to make sure all my products are stickered, right? And nobody else can sell my stuff. The problem is that if you're selling stuff in other channels, such as Walmart or on your own Shopify site, and they don't have those stickers, that's a violation of the policy, right? Because Amazon doesn't want it just on Amazon. They want it in the supply chain, right? Because they don't want the transparency program to be used as a way to block other sellers. Amazon loves resellers. That's their whole. This is how they violate MAP agreements, right? They get sellers to go out and source these products way cheap from Walmart's clearance rack. I mean, if you've never been to a Walmart clearance rack, I used to work for Walmart corporate. I mean, it's amazing what they do when they need to clear out stuff, the negative margin. I mean, things that sell for $100, you can go to that Walmart clearance rack and buy for like $2. And you go on Amazon, sell for $100. I mean, it is crazy how much is out there that you can arbitrage. So Amazon wants that. They love that because that makes prices lower. That makes Prime members happy, right? So they're digging it. So they don't want you guys going in there and filing these brand registry complaints, taking people down who are, resellers of authentic product.
The other way that this was done, and all legit, and it could have transparency on it or not, and that was these rebate companies that would put up 100 units. And then what would happen is somebody would go out. There's a course on this, by the way, how you could screw around with these rebate companies. Most of them don't exist anymore, but you could go create 100 different Gmail accounts and just go in and take up whatever amount that they were offering. And now you could take it and you would be legitimately on arbitrage selling that product against the competitor at whatever price they wanted, because they got it for free. So just because that, and you're so right. Transparency, first of all, is not an Amazon program. It's a program that you have to sticker every single product. Now, if you are a wholesaler, or if you want to wholesale and you give a pallet away to somebody, well, you just opened yourself up to a competitor on Amazon. Amazon is a free market. It doesn't mean that because you own the brand that you just get that there's no competition on your brand. So you have to protect yourself. And I know that I've talked about reseller agreements before. If you are working with wholesale, I've gone through a nightmare with one company that had 23 sellers on the product. None of them were counterfeit. But what had happened is they had major wholesalers around the company, country around the major distributors around the country who sold them to other companies, who all of a sudden started selling. In the wholesale agreement to the distributor, it says that they could not sell on Amazon. But all of a sudden, 23 people at the most, it went from 16 to 23. You couldn't get them off. You couldn't scare them off. And they had the legitimate right to do it. Scary. Well, actually, there was a glitch, but it was going to cost way too much money. And that was, they had the original wholesaler agreement that said that they were not allowed to wholesale, or anybody who they're selling to could not wholesale on Amazon. But didn't stick.
Those agreements are really hard to enforce, even if you have them written. They're the FTC's position on a lot of this stuff is more like along the lines of, you're really limited in how much you can limit once you sell the product to a, wholesale, how much you can really restrict it, runs into a number of antitrust issues, whether it's, you're creating territories, whether it could be seen as price fixing with MAP. So the way you're supposed to kind of handle it really is you're supposed to say, like, okay, here's what I want. You let the wholesale buyer know, okay, here are the rules.
Yeah.
Right. If they don't follow the rules, you're not really going to probably have much of a cause of action, as much as you just have the right to just stop doing it. And that's how the FTC views this, is like, a lot of these restrictions you want to put probably may not be kosher, but you always have the right to choose who you do business with and who's not. So if somebody isn't playing ball, there's nothing wrong with you just saying, hey, I'm not going to do business with you anymore. I'm not going to sell to you. You're done. Right. Yeah. And that's really how they want you to handle it, without, they don't want sort of like cross policies, restricting certain movements. That just gets into a whole host of antitrust issues. But people do it, but just those contracts aren't always enforceable, right? Like you're still going to be limited to just sort of how do you control your supply chain, right?
Yeah.
And how do you prevent others from getting your products? And that's really what Amazon wants you to do. But they don't want you using their tools. Like, they're very clear. They don't want you using their tools for basically controlling distribution. That's not what they're for. And they're very clear. Once they get a whiff that that's what you're doing, then it's like it's shut down city. So
one last comment before we get into the questions, and we got a bunch of them. But
sure.
I have been so abused over the years, but they're all learning lessons. I've got an MBA on the streets in learning lessons. But I went out, I had contractors back in the late 90s. I was outsourcing a lot to India, and had some really great early on websites that were developed over there by a bunch of artists, until Getty came around in the mid 2000s. And all of a sudden, these are websites that I had for a while, and they nailed me. Mm-hmm. They came back with, like, one website was $30,000 that they were looking for. Mm-hmm. Others, I think if my memory serves me right, it was over $300,000 in fines that they wanted. And I ended up negotiating with them, but it turned out that the contractors that I was working with did exactly like you said a little while ago. They never bought the images. They didn't even buy them. They just grabbed them. And I ended up, and how stupid is this going to be if I have to go back to my clients who were, there was a bunch of them, And this could have been a year old, 2 years old, 3 years old, and say, oh, those images, you owe me $30,000 for them, or three, like it was about 3,000. It was, we nailed it 10 to 1. So anyways, $3,000. I had to pay for all these. I had to pay for them all because I couldn't go back to and it was a learning lesson. But you are 100% right. And if you're not looking at that license and the extended license, you are opening up yourself for trouble. The algorithms are so good, they'll pick it up, and one day you'll get nailed. If it's not Getty, it'll be somebody else.
And there's software now. The law firm has software now, and they go. And so, like, if I'm a photographer, I can upload my image to the software. And then if they find somebody using my image, they'll go after them for it.
Yeah.
So it's like, really, they've created these programs where it's like, and my clients get nailed with this all the time. It's like, oh, you use this image made by Bob Smith of New Jersey, and they're like, now we're going to go after you, and they revoke the settlement. It is a problem, and we see it a lot. And like I said, it makes buyers nervous too. So like, even if you haven't had an issue, it makes buyers nervous when you don't have that title because they're worried about that. Now, the solution, of course, the other solution is to say, fine, let's just make new photos and let's budget for what that costs and try to negotiate. Okay, we'll hold back, a couple grand or whatever it costs to make new photos that are traceable, but it still makes people nervous. And another thing people don't realize with infringement, it's a little tricky. Infringement is one of those, especially trademark and copyright infringement. It's one of those where you can actually, having an LLC can almost be useless because they try to make the argument that you individually were the person who committed the infringement, right? You committed the tort, right? Not your company, right? But you, by posting and publishing this thing, right? You're the one who commits infringement. So it's super important to have your head around that stuff because your LLC may not, people think I have an LLC, so I can only be liable to the extent my business has assets. I can't go after me personally. No, not the case necessarily with infringement cases. They can, there are causes of action where they can say, no, you were the one who committed the tort here. You're the one who infringed, not the company. You did it. You're the one who went out and put this picture up on the website. May have been for the benefit of your company, but you did it. So therefore, we're gonna go after you for infringement. So, all the more reason to just have this stuff buttoned up and be able to, be on top of it.
That's where layering your companies is important, and we could talk about that another day.
Oh, absolutely, yeah. All right, my old corporate days is my love. Corporate and tax. That's where I started out in the world.
Well, we've got a bunch of questions. How's your time doing, Paul?
I'm good. I'm sound as a pound. I'm good.
All right. So if Paul's sound as a pound, then perfect. Let's get over to some questions.
All right. Yeah, we got lots today. From Neil, my Amazon guy says that a lot of sellers' brand registry and A+ content are being shut down because Amazon has a problem with a bunch of lawyers that filed the trademarks. Why is this happening?
That's a great question. I hope Amazon doesn't take issue with us. We were the #1 cited resource in the antitrust subcommittee investigation. We do a lot of work to fight for sellers. We have a pretty strong reputation. But yeah, I have been reading these cases, but I don't know what's there have been lawyers who've been involved in there's been a lot of shady things going on in the trademark office. And I read one article where the woman who was basically hired to fix the problem got implicated in this shady trademark dealings, and Amazon put her on a no-fly list. I think that's pretty ridiculous. Considering how it's being executed, I suspect this will probably end soon because the last thing you want to do is start defaming lawyers because it sort of becomes defamation, right? Amazon's basically telling your client like, "Hey, your lawyer is a scumbag, and we're not going to respect the trademark they filed." I think that's not a smart move. I think whoever thought of that idea, this is fairly new. I think it's going to end probably very quickly. I think they're going to go back to the drawing board on this one because it doesn't make a lot of sense.
I think I should mention too, you and your firm are to thank for the whole Amazon sales tax thing going away.
We fixed that. Yeah, we are definitely a part of it. We spend a lot of time. So we created a nonprofit called the Online Merchants Guild, where we go out and fight issues that are important to sellers, and we try to sort of build a trade association for e-commerce businesses, which did okay. It isn't done great. It's hard to get small businesses to buy into this. Where I'm from, where I grew up, I was a corporate lawyer for Microsoft, Walmart, General Electric. That's how you play the game, right? The way you level up on Amazon, right? If you're afraid of Amazon overreaching you because you're just this little guy, is you band together and you build a force. And that's what we tried to do. And we were very successful in many things. We won some tax cases. We successfully challenged the overreach of price gouging during the pandemic, where our client members were basically afraid to sell a Nintendo because they thought that was the same as selling, a mask, because in some states that's how it certainly felt like, trying to make you feel. N95 mask versus Nintendo versus, steak, spices. It was crazy during the pandemic what we were dealing with. So we created this association to do that. And one of our missions was to fix sales tax. And we always believed that even under the law prior to 2019, which was when California switched over, states started doing the switch over to self-collection, Amazon being the collector in 2018, but it really didn't take stride until 2019 when California switched. And that's what we lobbied for. But yeah, that was super, super important, because we really did not believe that small businesses should have to file and report sales tax, income tax, property tax in 50 states. 50 states plus 12,000 like micro jurisdictions. That's just suicide. And if anyone's thinking that that's what you need to do, probably talk to us first, because it's not the move. This is a problem that Shopify sellers currently have, and they're trying to struggle with when's the right time to register, how do you register? Because it's super burdensome to have to file all these tax returns, and a lot of
and expensive.
Super expensive. Yeah, you're going to spend 6 figures. It's going to seem cheap at the front end. It's not, because they're not telling you everything you need to do. The sales tax companies are just selling you sales tax software, but they're not telling you about income tax. They're not talking about audit defense. You're not talking about, having a staff of tax professionals on your team. You basically have the same tax filing obligations as Walmart if you register in all 50 states. It's crazy. But Shopify sellers, like we have clients who are Amazon sellers who basically what they do is on their Shopify site, they just link back to Amazon, because they're so wanting to avoid this whole registration in all the states thing that they'd rather just give Amazon a sale, even though they make less money, because at least they don't have to register to collect sales tax. It'll get done for them, and they don't have to take that risk. So we're seeing a lot, which is unfortunate. We actually met with Congress Small Business Subcommittee through the Online Merchants Guild right before the pandemic, like literally a week before the lockdown. We had a big hearing in DC, and we had a bunch of e-commerce companies come out and testify. And then we had that little pandemic thing, and it just all fell apart. But we were trying to get Congress to acknowledge that, you're giving Amazon a little bit of an advantage here because it's so complicated to do your taxes on Shopify. So, but yeah, it's an important issue, and at least for Amazon sellers, at least on the sales tax side, it is sort of fixed on a prospective basis. So you younger Amazon sellers may not even know what we're talking about, but definitely be thankful that you're not dealing with what the poor people had to deal with who were selling between 2012 and 2019.
It was horrible.
Oh yeah, we still have cases. People were getting their bank accounts levied on the day before Christmas. We had a case about that. It was just nuts. People were getting told they owe their life savings to California going back to 2012 and 2020. They were told that. It was just nonsense.
I do have a client that I warned and rewarned about this. He was selling into Europe, and he got a nasty letter that he owned $1 million or 1 million euros in back taxes.
Jeez.
Yeah. He just thought he could just go in there and sell and not follow the rules. But anyways, this is so stupid, but you got to follow the rules one way or the others. And we had to back in the day. And, thanks to guys like Paul, we don't have to do that anymore. So on behalf of the Amazon sellers, thank you, sir.
You're welcome. But it got me I got typecasted. That's the only thing I don't like about it. I got typecast as the tax guy. I think less so now, but people are like, I have clients who come to me like, oh, I didn't know you did M&A. I didn't know you did exits. I didn't know you did that. I'm like, I thought you just did sales tax. I'm like, no, that just was a very important issue that was close to my heart. It was constitutional law in the U.S. I wanted to take it on, but no, it's like we let it think.
We never even got into that. We haven't even touched that today. We'll have to have you back on another podcast to go over some of that stuff.
Yeah, but it was really funny. But I love doing it. It was really, really fascinating, really a lot of fun to go out to California and many times meet with government. And really, we were registered lobbyists for on behalf of the sellers. We were registered as a lobbying organization in California and getting the laws changed. I was testifying before these various committees, and it was a lot of fun. And we got it done. And then we pushed that to the other states. We won a court case in Pennsylvania last year saying that, FBA is not Nexus, for anyone who knows what that means, which was really important. So yeah, we're getting things done. So
Awesome. All right, next question.
Okay, this one is from Spencer. I saw a brand copying my likeness and I reported them to Amazon. My brand registry was then taken away. I appealed, but the appeal was denied. My mark is still pending. What do I do to get my brand registry back?
yeah, those are tough cases, right? So I mean, one is okay. I mean, my first concern is the statement, my mark is still pending. So if you don't have a valid mark, you shouldn't be using a brand registry. I mean, you're not even supposed to be, right? You shouldn't be reporting brand registry violations. Amazon doesn't care.
That's right. Yep.
About a pending mark. They don't care. Now, you may have damages, but you can go to court and get those damages. Of course, court is very expensive. This is something we teach our clients too. This is very much our philosophy. We are a law firm that is geared to keeping our clients out of court because we don't believe that there's, not a lot of justice in the justice system for the average Joe or Jane, right? It's very expensive to get a remedy in court. So yeah, realistically, you're not going to go and sue this person with a common law trademark that's pending registration, but don't use Amazon's tools. So that's step one. What I would try to do is when the mark registers, write a POA, write a plan of action, explaining why, the mistake you made and that how you're going to, do better, that maybe you took some training on brand registry. That's what my team does. That's why we have Seller Basics, and we've sort of turned account health into almost like an insurance product where it's like $100 a month, where if something happens to your ASIN or your account, we just go work for you and help you get back online. We sort of started that business model of account health that way. That's why we do it. But I have a whole team who handles these every day, and that's kind of where I would be focused. I'd be focused on first getting the registration, because there's no point in arguing about it if you don't have the registration. There's not much you can do, right? I mean, you need the register.
That's right. Registering with brand registry is just registering with brand registry. Nothing counts until you get that trademark. So what was the other thing I was just going to say? Blah.
A+,
Okay.
you get the A+ content, right? But you don't get,
right.
You wouldn't be
you get all that.
Yeah.
Okay. One of the things I was going to say is Seller Basics, which is Paul's organization. That's a subscription format for legal. So if you're running into issues, it retains a lawyer. I don't know if that's the proper word, but you've got somebody that you can call if you have problems.
It's a different business model. I know other folks have taken it differently because that's due to contractual concerns, I guess. I don't know why. I don't really know. But we invented this business model, and our business model, Seller Basics, is not a law firm. Seller Basics has an account health department that helps you with account health issues, and you get access to a network of lawyers. So I'm one of the law firms, or some other lawyers, and we will basically quarterback. So we'll listen to your case, we'll connect you with a lawyer who's got the subject matter expertise or knowledge to kind of help you. If it's not one of the lawyers in my firm, we've got other lawyers on the network who will take your call and help you through the issue. But the lawyers are separate and apart from Seller Basics. They provide, that for them, that's lead gen, right? They provide that free 15-minute consultation. But after that, it's between you and the lawyer to figure out how you're going to work together, right? But at least you can get answers. And I think that's so important. And that's why I invented this program, because this started from sort of my old days when I first started out, where I would tell my clients, once you become my client, if you ever have an issue, right, just call me. No matter what the issue is, just call me. I'll, don't go to sleep. Don't stay up all night worrying about it. Just get on the phone with me and let me know. And in my opinion, a lot of people who get in trouble with the law, who have legal problems, a lot of those problems are preventable. That's what I've always noticed. And that 15-minute phone call that Seller Basics gets you as part of your $99 a month, that 15-minute phone call, it's like the Geico commercial, right? It could save you your business, right? Instead of saving you, $500 like a Geico, but it's like that 15-minute phone call with a lawyer can save your entire business, because we can jump in before you make a decision and say, don't do it that way, do it this way, right? And people miss that opportunity. And tax was a perfect example. I mean, I can tell you how many clients who are fighting off multi-million-dollar tax assessments because they never talked to a lawyer beforehand. They just thought they knew what to do. I'll just register my business in all 50 states. No, not the move, right? So that's a class example of had you talked to a qualified lawyer beforehand, we could have saved you a lot of problems in the future.
Okay. Next question.
All right. The next question is from Neil. How much does it cost to add a class to your trademark?
Whatever the filing, I think it's the same. I think it's whatever the filing fee is. I think we charge the same. What we charge, I think it's our $7.99, including the fee. I'm not the one who files it. I wish I had Bethany, because she's the trademark person on my team, so she really gets into the weeds. I actually hate the trademark office website. I hate everything about it. I have some more stories about that too. I would imagine it's whatever, it's a couple $100. So I think for us, it's probably about the same what we charge for a class, because it effectively is a similar application. Like you have to file a new application. So I would imagine it's probably the $7.99. But I would defer to my Bethany on my team to clarify whether that's the case.
Okay, and this one's from Chuck. My brand registry is now revoked because I filed copyright infringement wrong. Now I'm forced to hire an attorney to get my brand registry back. Is my issue of brand registry being revoked something your firm handles?
We do, yeah. I mean, these are cases that's why I'm out here telling people to be careful with the brand registry, because we're kind of tired of getting these cases. And we're like, we want people to be more careful with BR. So it is something we handle. These are not easy cases. I'm not going to say we're going to definitely get you sorted, but I mean, we've had success in the past. Sometimes we're not successful. It's sort of weird sometimes. Sometimes it depends on the degree of how bad the violation is. But, if we take the time to learn your case, we might be able to spin a story that, is reasonable to Amazon. It says, you can get those rights back. But, yeah, we do. We definitely handle it. It's something we do quite a lot of. Like I said, I don't want to do it. I'd rather, as much as, yeah, sure, we get paid for it, but it's like, I like to get paid for happy things. I don't like getting paid for sad things. So I prefer my clients, be very successful, exit their businesses. We help them, those sort of sad things in the interim, those are never fun. So if I can do anything to prevent it, I'm going to talk about it.
Okay, and just a couple more questions from Simon. Can you register copyright and design registration if your product or image, etc., has been in the public domain for any length of time?
Copyright, you can register. Copyright exists the moment, right? Like if I take a picture of the Eiffel Tower, my photograph of the Eiffel Tower technically there's copyright, right, instantaneously, right? Or if I draw a picture of the Eiffel Tower, copyright exists instantaneously. So I can register that at any time. And you're talking about registering a design, and I think you're talking about design patent. No, then you have a time limit, right? You have 1 year from when it's commercially shown. You have the grace period. But copyright, you can always register anytime, right? Based on, right, you just have to know the date it was created and who the author is. So if you're the author, or did you commission somebody else to do it for you? You just have to have that key information. Yeah. So, but yeah, you should be able to get your copyrights in anytime.
Okay, and then we got this from Tony. Is it worth paying extra for the Amazon IP Accelerator?
Honestly, no. I mean, I don't understand. I don't really know what the point of it is anymore. I mean, back in the day, like I always thought we were done with trademarks, and I was kind of happy, honestly, because I don't love trademarks. I don't love doing the work, but I was kind of happy. Like I was like, all right, we're just not going to be in the trademark business. It's fine. All right. Now that I have Bethany, I love trademarks again. But back then, I didn't. And I hate using that website, and I hate filing trademarks. And I was happy. But so yeah, they created that program, and originally, like, you had to go through that program to get that early brand registry access again, which really just turns on your A+ content. But now I don't know the difference. I mean, if I file your trademark, I'm going to give you a serial number, right? Not a registration number, serial number. And with that serial number, you're going to turn it. You can go on your Amazon website, and you're going to unlock the brand registry. You can unlock the A+ content, just not the reporting. I don't know what the IP Accelerator gets you in addition to that. And as far as I'm aware, it's no different. I mean, we do trademarks all the time for people who are planning to use brand registry, and we've had no issues, no complaints. It's just the way it works. So I'm not really sure what the status of IP Accelerator is. I'm not surprised we're not in it, because we don't have a long history of trademarking. We've even sued Amazon from time to time in various complicated litigations, just again as part of the Online Merchants Guild and other things. And like I said, we were the #1 cited person in the antitrust investigation into Amazon's mistreatment of sellers, and we worked a long way to try to kind of get Amazon to treat sellers better. But I don't think we're the most loved law firm for that reason. But I think we do have a good relationship with Amazon, just built on a different foundation than being sort of cooperative shows. We're very much, try to be the counter voice, right, to the
Right.
Amazon machine.
All right.
Okay, and I think that's pretty much it. I think we covered anything, all the other questions. So
All right. So let's give it about 30 seconds. If you're new to the podcast, this is where we go to the Wheel of Kelsey after the sponsor. But hashtag Wheel of Kelsey or tag two people, you'll get a second entry. We're going over to a sponsor. When we come back, we'll do the Wheel of Kelsey. So get that in right away, and we'll add you to the wheel. Okay, Kels, let's hit the sponsor. This episode of Lunch with Norm is sponsored by Rebate. Attention sellers and brand owners, want to reach more shoppers and boost sales? Rebate's platform connects sellers with shoppers seeking great deals on new products. They make it easy to offer promotions, handle rebates, and ensure seamless redemptions. With countless reviews from satisfied customers, Rebate is the go-to solution to increase your sales. Visit rebate.com today and start reaching more shoppers. Now let's get back to the show. Okay.
All right, here we go. The wheel's coming.
The wheel is coming.
All right.
here we go.
It's time for the Wheel of Kelsey.
Okay, a
Alright.
bunch of people today.
Yeah, thank you for entering, everyone. I'm going to shuffle these up, give this a spin, and if you are the winner, please email me kate@lunchwithnorm.com, and we'll get you your prize. It looks like it is.
Oh, Tom, he got it.
All right, congratulations, Tom. Just email me kate@lunchwithnorm.com, and we'll get you over to Paul.
Okay.
Yeah, my email address is easy. It's just paul@ecom.law. It's or paul@solidbasis.com. So very easy to find me.
Perfect. Well, Kelsey will arrange all of that. All you have to do is send your email over to k@lunchwithnorm.com, and he'll make sure that you get the information over to Paul. All right, sir. The Wheel of Kelsey. There we go.
Cool. It reminds me of this old British comedy show called Alan Partridge. I don't know if you ever watched it with Steve Coogan. I don't know. Anyone?
No, I know Stephen Coogan.
Yeah, it was like one of his first characters that he ever created was this guy, Alan Partridge. It's like this radio host in England. It's like one of the funniest shows. In the first season, there's a scene. It just reminds me of like the Wheel of Kelsey. Remind me of that for some reason. But I don't know, maybe the British people on here don't know what I'm talking about. But,
We'll do a live Wheel of Kelsey where we actually Velcro him. He can be the arrow at an event, maybe BDSS, and see what happens there. Paul, it's been awesome having you on. This has been great. I had 5 or 6 things we were going to get into today, and we ended up on IP, which is great. We cleared up a lot of myths and mistakes that sellers are doing. So just wanted to thank you, and we've got to have you back on.
Love to be back. I love talking about this stuff. We really try to stay at the front of everything that's going on. And love talking about it. And the other thing I'll say for anyone who didn't win, for those of you who didn't win the Wheel of Kelsey, the other thing we do offer is free. If you are planning to sell your business and you just want to, even if it's in the next couple of years, or you just want to know about it, talk about it one-on-one, ask the questions, you can always email me and set up a call, and we do that complimentary. That's no problem. So we always want to help people get on that track. But thanks so much for having me on the show. And I'd love to be back and have lunch again. Or maybe dinner, or maybe a snack. Maybe just a snack time with Norm. Maybe just
snack,
a quick,
a bite.
Snack.
Just
a nosh, a nosh with Norm.
There we go.
So you can do that.
Okay. Well, are you going to be going to that New Jersey event, or are you going to Accelerate?
If you send me a link, I'll go. I mean, it's. I guess I have to go to the Meadowlands next week for like a wholesale conference. So it's not far. I mean, I'm either between Florida and Jersey all the time. So I'm easy enough to get down to the Meadowlands.
Oh, that'll be good. Another cigar.
Yeah, I love exactly. So thank you, everyone. Thank you to the audience, and thank you so much, Norm, for having me on here.
Want more great information? Don't forget to subscribe by clicking here. Also, If you want to check out our latest podcasts, click over here.
Lunch with the